Thank you, Andrew. Yes, well, let me just get the slide in the right place. Thank you very much. Today, I'm just going to spend the next 15-20 minutes or so talking about the recent Australian decision in Pell and the Queen, which was handed down earlier this month. And I'll go through the consequences of that decision for the future of jury trials in common law systems. The background to all of this is that Cardinal Pell is a senior cardinal in the Catholic Church, and he was once Archbishop of Melbourne in the 90s. He was charged with and convicted of several historical sexual offences in relation to that period of time. And the case made its way to the High Court in Australia, which overruled the guilty verdicts of the jury and substituted acquittals. And that decision has, perhaps unsurprisingly, caused considerable comment and speculation about the effect on future jury trials. So I'm not talking today about the facts of this particular case so much, or whether we should be prosecuting these kinds of cases, historical sexual abuse. That's a question for another day, a different kind of seminar. But the question here is what that Pell decision means for the role of jury verdicts in criminal prosecutions generally. And just a little bit about me before I move on. I studied law in Australia, and I subsequently worked at the High Court of Australia for a judge as a judicial assistant. That judge is no longer on the bench, he's retired. And I've since come to the UK to practice at the criminal bar in England and Wales, where I've been for several years now, and I regularly prosecute and defend in the Crown Court. So I'm going to give a bit of background on the Australian system, the precedential value of decisions from common law countries. I'll tell you about the trial briefly, the first stage of appeal in the Victorian court, and then I'll go through the principles and the decision made by the High Court. So first of all, the Australian system. By way of background, it won't be a surprise that the Australian system is quite similar to the England and Wales system because it inherited its common law system from here. The High Court of Australia, often abbreviated to HCA, is the final court of appeal. And its decisions are binding and they set legal precedent. So it's the equivalent of the UK Supreme Court. Each state within the Commonwealth of Australia, there are 6 states, they have their own independent parliaments and courts, and they can regulate their courts. This particular trial took place in the state of Victoria. And again, unsurprisingly, the format of a criminal trial in Australia and in Victoria is very much based on the same principles as the ones we use on a daily basis here. So a judge presides. The judge determines questions of law, and a jury of 12 members of the public follow the directions of law and determine questions of fact and reach a verdict. There are barristers on both sides, prosecution and defence. They test the evidence in an adversarial system, and the burden and standard of proof are the same. So the prosecution has to prove its case beyond a reasonable doubt. Now in England and Wales, we now call that being sure, but it has the same source and effect as the beyond reasonable doubt test. A quick note on the hierarchy of courts in Australia. The terminology might otherwise trip you up. You'll get your state court of first instance, magistrates court, county court, trial division of the Supreme Court, which deals with more serious cases, homicides, terrorism, and so on. From that, you can appeal to the state appellate court, which is called the Supreme Court, and it has a trial division and an appellate division. So the appellate division of the Supreme Court in the state is the most senior body in the state. Above that, you've got something off to the side here. You've got the Federal Court of Australia, which I'm not going to bother with right now. That goes in a slightly different structure. But for our purposes, you then appeal from the state appellate court to the High Court of Australia. So the High Court is above the Supreme Court, and I think it may be the only common law country that's reversed its terminology in that way. That brings me neatly on to the Commonwealth. A discussion of the Pell case is a purely academic one, unless, of course, it's of some application to us here. And there's a circle of Commonwealth countries that like to refer to each other's decisions. And you see that the main ones here, Australia, Canada, Hong Kong, New Zealand, they're all countries that have at some point been heavily influenced by effectively being territories of the British Empire. So they have the same legal system, quite often the same language and culture that they conduct the law in the background of, and so a very similar process. And so the precedential value of those decisions is, of course, not binding, but you'll see references to these courts appear regularly in textbooks, Archbold, decisions in the Court of Criminal Appeal Division and in the Supreme Court or House of Lords. And the experience attached to judges of these courts are considered comparable to those of judges here in the Court of Appeal or the Supreme Court. And you'll remember the slide that Jonathan just showed us, the list of non-Hong Kong, non-permanent judges in the Hong Kong Court of Final Appeal. It's full of members of the UK Supreme Court and House of Lords, but it's also got a considerable number of former Australian judges and Canadian judges. There were 2 Chief Justices there, a puisne judge from the High Court, a Chief Justice of New South Wales, and the former Chief Justice of Canada, just as an example. So the answer to the question, what the value of this case is that it's potentially very persuasive here, depending on when and why you cite it. So the trial itself, as I said, Cardinal Pell, Catholic Church cardinal, it was big news when he was being investigated for this, and that there were actually several investigations involving him. Only one of them got to trial directly. So this trial concerned 5 allegations involving touching and abusing 2 boys in a cathedral in Melbourne. And the 5 charges related to incidents alleged to have taken place in 96 and 97 against 2 choir boys who were called A and B in the High Court. So we'll call them that here. Now, A gave evidence, B was deceased by the time we got to trial. A gave evidence of offending that he witnessed against B as well. And there's obviously no question of consent or anything like that. They were both children at the time. You can look at the High Court judgment and indeed the other judgments, I'll give links later on, to see the detail of the evidence. I'm not going to go through it in full detail, but in summary, Pell's defence was that the actions complained of never happened. And not only was it just a denial, it was his defence was that the circumstances in which it was said to have happened could not have existed. They just couldn't have transpired based on the way that the cathedral was set out and the clothes that he was wearing, etc. He didn't give evidence at trial, but there was an interview that was in evidence. I'm not going to spend a lot of time on this particular slide. It's quite complicated because the central issue, as far as the High Court was concerned, was the inconsistency in evidence and the fact that some of it wasn't challenged by the prosecution at trial. Refer to the judgment, please, for more detail about it. In summary, as I said, A claimed that the offences had taken place in particular areas in the cathedral and at particular times, and at least 2 separate days on which it was said to have happened. There were a number of witnesses, and we're talking, I think, at least 24 witnesses who had worked in the cathedral at the time, and they gave evidence of varying degrees. Some said it was possible, some said it wasn't possible for the cardinal to have been, or the archbishop as he then was, to have been where A said he was at the time the offences happened. And owing to the way that Australian law deals with shall we say, hostile evidence, the prosecution was allowed to cross-examine some witness as hostile, and they did so, but they didn't challenge everything that was said by those witnesses, which, if believed, would appear to suggest that the allegations couldn't be true. So the prosecution said, well, although we haven't put to every witness, you are mistaken or lying about the practice that was in place at the time, undoubtedly that evidence was inconsistent with the prosecution case as a whole. And so the issue became whether, if the prosecution hasn't challenged some evidence, it's not a Section 10 agreement equivalent, it's just that they haven't challenged it, and the prosecution case undoubtedly is inconsistent with that evidence, the jury, being fully aware of both sides of the argument and the flaws that the defence pointed out, is the jury entitled to find that the prosecution case is true and the other evidence, even though unchallenged, couldn't be right? Well, the jury didn't have a problem with this in the second trial of this case. There was a first trial, that was a hung jury. In the second trial, unanimous conviction, December 2018. And it's of note, especially given our current circumstances, that in fact, most of the evidence in the first trial, the hung trial, was video recorded, and that was replayed to the second jury. So the second jury never saw A giving evidence live, in particular, although there was other evidence as well, but they watched all of his examination in chief and cross-examination on the video. And the whole trial was video recorded, and I'll come back to that later. So Cardinal Pell convicted, sentenced to 6 years. Again, I'll give a link to the judge's sentencing remarks, which are quite detailed and very carefully thought through, because he knew it was going to be read widely. As I said, 6 years in custody. We then go to the appeal. I'll skip through this fairly quickly. The first level of appeal was to the Court of Appeal of the Supreme Court of Victoria. And remember the terminology we talked about in the hierarchy. So you've gone from your trial court up to the Court of Appeal in Victoria. And you've got there a 3-justice bench, which is normal. The composition of that bench is pretty impressive. You've got the Chief Justice of the Supreme Court, so the most senior judge in Victoria, and the President of the Court of Appeal, who is only just junior to her. And you've also then got Justice Weinberg, who is a Justice of Appeal. And this court was applying a statutory test. Was this jury's verdict unreasonable, or could it not be supported having regard to the evidence? That's the Victorian test that they apply. And I said I'd come back to the video recorded evidence. These 3 judges actually watched quite a lot of the evidence from the video recorded evidence from the trial. And their judgment, if you look at it, is lengthy. And they go through in quite a lot of detail with maps and diagrams and so on about the evidence, their assessment of it. So it's starting to look a bit different from the Court of Criminal Appeal version, where it would be unusual to go into that level of detail of the evidence that a jury has already seen. So Court of Appeal in Victoria is a split judgment. There are 3 judges. 2 of them would dismiss the appeal and did, and 1 dissented. We then go up to the High Court, that is the Court of Final Appeal. The High Court has 7 judges on it. Not all of them will usually hear all the cases, but in this case, there were 7 judges hearing the whole case, which is reasonably unusual, although it does happen. It normally indicates a legal issue of some importance. In this case, it's not really a point of law that's at question. It's a question of fact. It's how the facts were examined and what possible conclusion could legitimately have been reached on those facts. And so the composition of the bench, Chief Justice Susan Kiefel and the 6 puisne judges, they apply not just the Victorian statutory test, they also apply the common law test for overturning a verdict of guilty. And that is a significant possibility that an innocent person has been convicted because the evidence did not establish guilt to the requisite standard of proof. Quick comparison to England and Wales. I don't need to remind you all of this. Do we think the conviction is unsafe? That's what we do here. Before this test was introduced in '96, we had a concept of lurking doubt. It still exists in the case law. rarely relied upon. You're welcome to go and have a look at the case law on it, but it's the best equivalent that I can find to what the Australian High Court has applied in this case. So the arguments in front of the High Court were not based on new evidence, and indeed the High Court didn't do what the Court of Appeal did below it. It didn't view the video evidence. It considered oral submissions from counsel, which took place over 2 days, and written submissions. The argument was that if you read this evidence, it simply could not support the convictions that the jury had delivered. And the prosecution failure or inability to challenge some of the evidence concerning opportunity, that's that inconsistency evidence, could the Cardinal have done what was said in the way that it happened? Did he have the opportunity to commit the offences? Prosecution failure to challenge that meant that he couldn't be convicted. And the High Court held that the evidence was so flawed that the jury could not have convicted Pell on these 5 counts. And it didn't matter. The fact that all of these flaws were pointed out to the jury by Queen's Counsel and junior counsel for the defence. It's not one of those cases where something was missing and not pointed out, and it was a key inconsistency where something has come out later that brings it to light. All of this was pointed out to the jury, and the jury's verdict must have meant that those points had been rejected. That was not enough for the High Court. The High Court said, our role is to ensure that innocent persons aren't convicted, and if that means that we have to say the jury got it wrong, then we will do that. It is worth looking briefly at some of the language used by the High Court. My suggestion is that they are turning to a kind of judicial review terminology here. They are referring to a kind of irrationality. It's almost a Wednesbury unreasonableness. No reasonable, rational jury with full knowledge of the flaws in the evidence could have found this defendant guilty. And so any jury that did was acting unreasonably and irrationally. And the only thing to do is to set aside the convictions. And you'll see there the language of a jury acting rationally, which is introducing this new way of looking at jury decisions. Again, in relation to count 5, we have similar language. So the remedy, well, there is a statutory provision for a retrial, but the High Court decided not to order a retrial or even leave the matter for the prosecution to deal with one way or another. They thought that not only was there the test, a significant possibility that an innocent person was convicted, but in fact there was no possibility that he could have been convicted at all. So in the manner of a judicial review, they've said, well, this decision was reached unlawfully, was irrational, unreasonable, but in the manner of a criminal court of appeal, they will substitute an acquittal, which they're allowed to do. But the message is clearly that any prosecution of these allegations was bound to fail and shouldn't have been brought. So the questions that arise from this, well, there'll be many. Some people will be encouraged by the possibility that the subjective and perhaps closed nature of jury trials might now be open to more scrutiny. Others might be uncomfortable with the way in which the jury's view of the facts was set aside. And if you read the High Court judgment, it is clearly revisiting an assessment of the evidence. My personal view is that we might be in this way going down a track that might not be that desirable, but it's worth thinking about what errors were made at the trial, if any, and whether they could have been dealt with before the jury decided to return a verdict. So here we would have looked at dismissal, Section 78 applications, possibly objections to various bits of hearsay, a stay of proceedings perhaps, or a no case submission. It is unlikely, in my view, reading through the High Court judgment, that the same result would have been reached here. But of course, there is always that possibility of a slow change over time to the way that we deal with these cases, where on the papers it looks like perhaps the prosecution shouldn't even be brought. The High Court would say, well, appellate courts should interfere with jury verdicts when the facts require it, and that's what they've done here. Consequences then, well, good and bad. Increased scrutiny of evidence, broadly speaking, good. Some will argue, well, you get a fairer outcome because jury system is inherently flawed, and especially when you're looking at old evidence and you're trying to judge the truth of what someone might be saying. On the other hand, you might want to consider whether it's fair to allow defendants, say in Australia, 3 goes at the evidence, because that's what's happened in this case. Cardinal Pell has had the same evidence looked at by a jury, looked at by the Court of Appeal, and then looked at by the High Court. And it's the top one that matters. Not all defendants will have the resources to access those avenues, even on legal aid. And jurors might find it daunting, difficult to deal with a trial process where they're expected to attend seriously and come up with a verdict, only to think that perhaps a court with greater power will revisit the evidence in a different way and remake the decision that they have taken their time going through and looking at. Equally, the same avenue that's open to the defendant here, for example, to appeal, have the facts looked at 3 times, that's not open to the Crown. If the jury irrationally acquit a guilty defendant, there's no recourse. And we've all had cases, any criminal practitioner will have had cases where the jury's verdict, whether you're prosecuting or defending, the jury's verdict makes no sense on the facts. It might be the verdict that you want for your client or for the Crown, but sometimes you get those cases where it just doesn't make any sense given what happened at trial. And if we ask the Court of Appeal to look at the evidence in all of these cases, to revisit it, as the High Court of Australia would suggest, we might be opening up a bit of a rabbit hole. This case is one that's raised a lot of questions going forward. This is an early assessment of what happened and where it might take us in terms of jury trials, the way they're treated, and the role of the appellate court. Thank you. Oh yes, and I've got there's an article on this which will give you all the links at the Secret Barrister website, and you can access that through the Fife Paper Buildings website as well. Thank you, Andrew.
Aparna, 2 questions for you, please. First of all, were the Pell verdicts majority verdicts? And if so, could that have been a contributing factor to the approach that the HCA took?
No, they weren't. As I said, the first trial was a hung trial, but the second trial was unanimous verdicts from the jury. And in my experience, I'm not sure that would have affected the way that the appellate courts would approach the question. That would be perhaps to unnecessarily undermine the concept of a majority verdict to begin with.
Thank you. And secondly, is there any overlap, as you see it, between the approach and the jurisdiction exercised by the High Court and the jurisdiction a judge has to accede to a submission of no case to answer, either if it's the same as in this jurisdiction at the end of the prosecution case or exceptionally at the end of a defence case?
Yeah, so I think here that would be a classic way to approach the problems in this case. But again, judges these days seem to be less keen to accede to those submissions, so you might end up finding yourself making that a significant ground of appeal after conviction anyway. In Australia, it's not so common to make those submissions, which might be one reason for the more robust position that the appellate courts take. But it does have the unfortunate consequence that you're effectively reviewing the evidence each time you go up to an appellate court, and that has all the additional problems or benefits that I've suggested at the end of the talk.
Thank you. Well, thank you again to both Aparna and to Jonathan for their talks, and more particularly, thank you for joining us. We'll be back at 3 o'clock next Thursday where we'll have 2 more talks. The first, a talk by Edward Jenkins, Queen's Counsel, and Ben Douglas-Jones, Queen's Counsel, on fraudulent trading, locked up in lockdown and beyond. And that will be followed by Miriam Smith talking about the recent case of FNM and the Director of Public Prosecutions about developments in the CPS Victim Right to Review scheme. Until then, please take care and stay safe. Bye-bye.
Bravo. That was really good.